Now we're going to turn to hear from Dr. Bridgette Baldwin. Bridgette is a faculty member whose areas of scholarly interest and teaching include criminal law and criminal procedure, evidence, critical race theory, which we're actually proud to say we really do teach at the law school, and international criminal justice. I'll also add that Bridgette is a very accomplished photographer and graphic designer, in addition to all her scholarly expertise. And Bridgette's going to be speaking about the court's criminal procedure docket this term. So I will turn the podium over to you, Bridgette.
Good afternoon. Although it might look like I'm not looking at you, I'm working with 3 screens here and you are over here. So it looks like I'm not looking at you. I'm going to share my screen and turn my video off because it seems to show better when the video is also not playing. So. Okay, you should be able to see my screen. See my screen? Yes?
Yes.
Okay, thank you. Okay, so I actually have 5 cases to go through. So if you multiply what Bruce did by 5, that's how long you're going to be here, okay? So, no, I'm just kidding. It's like going Zoom to get through all the cases. So the Supreme Court decided 5 criminal law cases this term, and 3 cases involved the 4th Amendment, 1 case involved the 6th Amendment, and 1 case involved the 8th Amendment. So hopefully I'll do justice and try to get through those cases with you all. So I'm gonna start with my 4th Amendment cases. The first case, I like to give a little facts because in criminal law, right, that's all that matters is what's happening and those facts that are going along with those cases. So in Lange versus California, Lange was driving his car and he was listening to music, honking his horn. It was apparent to, at least for officers, it was apparent that he might be drunk or under the influence of something. And so they began to follow him. And after a while, they turned on their lights to make him stop. And he didn't stop because he said he didn't notice them, but he also was about 4 seconds from his house. So he pulled into his garage and the officers followed him in and began questioning him. And it became apparent to the officers that he was drunk, so drunk that he tested at least 3 times over the legal limit. And so he was charged with driving under the influence, which is a misdemeanor in California. And so the issue before the Supreme Court surrounding this case was whether pursuing someone who has committed a misdemeanor authorizes police officers to go into the home or to the curtilage part of the home. There are 6 major exceptions that the law allows for police officers to enter your home or do certain things to individuals without having a warrant. And I've listed those 6 major exceptions to the warrant requirement on the board. And so consent, if someone consents, it essentially waives your 4th Amendment right. So it doesn't really implicate the 4th Amendment because you're by virtue and say, okay, I give you permission. A Terry stop is where police officers have the authority to investigate a crime. They have less than probable cause, but reasonable suspicion to investigate to make sure there's nothing funny going on. A search incident to arrest is another exception where once you've been lawfully arrested, police officers can search you in your immediate grabbable area to make sure that you don't have any weapons or evidence that you're trying to discard. The plain view doctrine, another exception, which kind of piggybacks some other legal reason for police officers to be there. So say, for instance, police officers have a warrant to come in your house and they have a warrant to search perhaps for an individual in your house. And as they're passing through, they notice that you have a candy dish full of cocaine. And they don't, although they don't have a warrant for that, plain view would authorize the seizure of that if it's immediately apparent to them that it's contraband. The automobile exception also gives police officers the right, if they have probable cause, to search your car without a warrant because of the inherent mobility of the vehicle. The justification is no time to get a warrant. And then lastly, which is the subject of this case, is exigency. Exigency involves situations where police officers are either in hot pursuit, but normally we had kind of understood that to mean of a fleeing felon. And so this case is trying to decide, well, does it have to be a felony or can it be a misdemeanor? We've also authorized it in other such situations that are listed there. Justice Kagan, I can't dissect her language, I'm sorry, but I'm going to take Bruce's word for it that she is eloquent in how she delivers her opinions. She wrote the majority opinion, and it was a unanimous decision. And she said the pursuit of a fleeing misdemeanor suspect does not warrant a categorical rule justifying a warrantless entry into a home. She said that such considerations of when police officers can continue to pursue and not should be done on a case-by-case basis or totality of those facts to determine whether or not an exigency existed. Now, she did acknowledge that when a suspect is fleeing, police officers might face some sort of emergency, such as the person is trying to escape, they're trying to destroy evidence, or they might cause injury to someone else. She says, but unless the exigency of the situation creates a compelling law enforcement need, there is no reason to believe that police officers need to act quickly. They need a warrant, even if going into the home or not going into the home would frustrate the arrest. Now, I think she was responding directly to the allegation that flight in and of itself creates an exigency when she said flight might create a need for police officers to act swiftly, but flight alone is not enough. The touchstone of the Fourth Amendment, of course, is reasonableness. And reasonableness under the Fourth Amendment, when it involves our home, generally involves getting a warrant before police are authorized to enter. We had three concurring opinions in this case. Chief Justice Roberts, his concurrence, if you actually read it, to me, it sounded more like a dissent. It was his opinion that flight alone is an exigency that should not matter whether the person has committed a felony or a misdemeanor. Pursuit implicates substantial government interest in public safety, poses a risk of safety to the officer, may create other exigencies that, and officers, when they're running after the person, they might not know, has this person committed a felony or a misdemeanor? It was his opinion that flight is never enough, it was his opinion that flight is never innocuous. I don't know, I would suggest that Jacob Blake might think otherwise. Justice Thomas also delivered a concurrent opinion, and he talked more about what should the remedy be. And it was his opinion, even if police officers had violated the Fourth Amendment, violated the constitutional rights by going into the garage without a warrant, he didn't think the remedy of exclusion should be allowed, in that the evidence should still be allowed in. Justice Kavanaugh, he kind of reconciled probably the decisions between Justice Kagan and Chief Justice Roberts. And he really said, really the difference between these two is semantics. In fact, in the opinion he wrote, he called it academic. He felt that at the end of the day, police officers will always be able to rely on an exigency, such as the risk of escape, and therefore they will always be able to enter without a warrant. And then he agreed with Justice Thomas that the remedy should not be exclusion. Coniglia versus Strom. Okay, this is another Fourth Amendment case dealing with the community caretaking function. So in this particular case, a husband and wife, the defendant and his wife, they get into an argument. And I guess it gets pretty heated because the defendant goes and gets his gun and he puts it on a table and he says, go ahead, shoot me, get it over with. That's a really weird way to end an argument, but in fact, that's what he does. And so in order to calm down things, Miss Caniglia goes to a hotel and stays overnight. The next day, she calls her husband. He doesn't answer the phone. She's worried. Oh, baby, he's committed suicide. She doesn't know. So she calls the police and say, hey, can you run by my house and do a well check visit for my husband? Police get there. They question him. He denies he's suicidal, but he agrees to go and get evaluated on the condition that the police will not take his guns out of the house. When he leaves, police officers renege on their agreement. They go into the house, take his guns. And so he's trying to get him back. So the issue that the court had to think about was whether or not a non-criminal community caretaking function exception to the Fourth Amendment warrant extended to the home. So does it apply to the home when police officers engage in certain functions that have nothing to do with the investigation of a crime? That's what the community caretaking function is. It was termed in this case, Katie, I think it's Katie, it might be Caddy versus Dobromsky. And it's types of intrusions that have nothing to do with detecting crime, investigating crime, or getting evidence, anything like that. It's more like when police officers go get the cat out of the tree, or when they're doing things that have nothing to do with investigating crime. Justice Thomas delivered the opinion of the court, and he noted that while Fourth Amendment may yield some exceptions and recognition that police officers might perform some civic duties beyond investigation of a crime, it doesn't mean it gives them open licenses to perform them anywhere they choose. He recognized that if you were to look at the decision in Katie and how it applied to this decision, it would defy the logic and holding of that decision and violate the Fourth Amendment's warrant requirement, because Katie involved a car search. This involves a home search. And he says the home is the most sacred place under the Fourth Amendment, and without a warrant, exigency, or any other exception, it becomes unreasonable and unconstitutional when police officers enter. He says the court has repeatedly declined to expand the scope of the exceptions to warrant requirements to permit warrantless entries into the home. And again, here we have three concurring opinions. Justice Alito, he agreed with Justice Thomas, but he wrote separately, which is, a lot of times what justices do. They write to tell you about what was not written about. And so in his concurrence, he writes about three things that he thought the court didn't decide. And he starts off, he's like, there's no special Fourth Amendment rule for a broad category of cases involving community caretaking. And he also talked about, however, community caretaking might arise in other contexts, and those might be analyzed differently under the Fourth Amendment. So what he wanted to do was isolate this case simply about, this was about a community caretaking involving suicide, but there might be another community caretaking about something else. And we would do a different analysis under the Fourth Amendment. Justice Kavanaugh, he also wrote a concurrence, and he indicated that the community caretaking exception is really just a spinoff of the exigency standard, and that exigency permits warrantless entry when police officers have an objectively reasonable basis to believe that there is a current ongoing crisis for which it is reasonable to act, and police officers' actions inside the home are reasonable. So in his opinion, really, if they have exigency, we don't really need to resort to this analysis of whether or not the community caretaking would apply. Justice Roberts' one-paragraph concurrence indicated that a warrant to enter a home is not required when there is a need to assist a person who is seriously injured or threatened with such injury. He concurred with the court because he felt there was no indication that there was a person in need of serious injury or threatened with such injury. My last Fourth Amendment case is actually a 1983 action filed by Torres versus Madrid. So This case is very interesting, and the facts are actually very interesting. Police officer had a warrant looking for somebody else, and they just so happened to see Torres sitting in a car with someone else, and they approach her, but they're not in uniform. And so when they approach her, she thinks she's being carjacked. So she pulls off. And there is some indication maybe she might have was running in the path of the officer, maybe she wasn't, but in any case, they start shooting at her. And one of the bullets hits her, a bunch of them hit the car, but she keeps on driving until subsequently she crashes. Later on, she's arrested and things like that happens. And she files a 1983 action saying that her constitutional right was violated under the Fourth Amendment because the police used excessive force to seize her. And remember, she never stopped after the bullet hit her, she kept going. So what the court had to look at was, well, can you be seized under the Fourth Amendment if a police officer shoots you, even though you're injured by the bullet, you never stop. So they never gained possession of you at that moment from that bullet. In order to analyze this case, the court had to go back to another case called Hodari D, and that was a 1981 case. The court explained what it meant to be seized. And the court says a seizure occurs when there is a show of authority. So when the police say stop and you stop, and submission to that authority, or application of physical force to restrain movement, even if it ultimately is unsuccessful. And the common law considered the application of force with the intent to restrain as indication of a seizure, even if the suspect ultimately escaped. This is a closer decision, right? Given by Chief Justice Roberts. And he says, well, the rule today I'm going to tell you about is a narrow rule. But a seizure occurs when an officer shoots someone, even if that person doesn't stop. It is the application of the physical force with the intent to restrain that constitutes the seizure, even if the person escapes. What was contentious between he and Justice Gorsuch was his distinction that he was trying to make between the seizure of property and the seizure of a person, indicating that case law said that the nature of the seizure can depend upon the nature of the object being seized. So a seizure, the court goes, only requires the use of force with the intent to restrain, even if it is ultimately unsuccessful. Justice Gorsuch wrote a dissent arguing that a police shooting is not a seizure covered by the Fourth Amendment if the victim is, one, not killed, or two, not subdued as a result. It was his opinion that a seizure requires possession. He said that merely touching someone might be a battery, or it might be an attempted seizure, but the Fourth Amendment's text, history, and precedent all confirm that seizing something does not mean touching it. It means taking possession. Okay, so I have 4 minutes to give you 2 more cases. Here's my Sixth Amendment case. My Sixth Amendment case actually is a review of the case I did last year. Edwards versus Vannoy. So Edwards was a Black man, and he was sentenced to life in prison for committing some robberies. He was convicted with a non-unanimous verdict. I can't remember if it was a 10-2 jury or 11-1 jury, but any case in Louisiana and Oregon at that time, those were the only 2 states that allowed non-unanimous verdicts. Then last year in Ramos versus Louisiana, the court said that all verdicts in state and federal criminal cases had to be unanimous. And so this case had to decide, should we apply it retroactively to those cases who didn't have unanimous verdicts and thus was still convicted? So as I told you at the time, only Oregon and Louisiana allowed convictions based on a 10-2 or 11-1 verdict. So in order to figure out whether or not this case actually could apply retroactively, The court had to look at the case called Teague versus Lane. And in Teague versus Lane, it kind of set up the parameters upon which a Supreme Court decision would apply retroactively. So an old rule applies both on direct and collateral review. A new rule, such as the one here, that jury verdicts have to be unanimous, generally applies to cases that are on direct review, but not collateral review, habeas review, unless there's a substantive rule. Okay, so we have substantive rules and procedural rules. So if a rule is a procedural rule, it does not apply on a habeas or collateral review unless it's considered a watershed exception, right? And a watershed exception is a rule that is necessary to prevent an impermissibly large risk of an inaccurate conviction, and it must change the understanding of the bedrock procedure elements essential to the fairness of a proceeding. Justice Kavanaugh delivered the opinion of the court, and he explained, well, we know that the rule in Ramos announced a new rule because it overturned Apodaca. And in order for it to apply retroactively to post-conviction release, it has to rise to the level of a watershed rule. A new rule will not apply retroactively unless it enhances the accuracy of criminal verdicts, but also bedrock tenets of fairness in criminal trials. And so he gets right to the point and says, you know what, we've never found one in 32 years since Teague. And so why are we just holding on to this rule when we don't think that these new rules will exist? Applying new rules retroactively, he says, undermines the principle of finality, which is essential to the operation of criminal justice. And new procedural rules do not apply retroactively on a federal collateral review. We get two justices who write concurrences. Thomas actually says, you know what, we didn't even need to go through Teague and do all of this stuff. We could have resolved this by applying the statutory text of the Anti-Terrorist and Effective Death Penalty Act statute, which says that if something has been if something has been decided on the merits in state court, then, and it's not contrary to federal law, then it has to stand and we can't review it. And since Edwards was decided when Apodaca, which allowed non-unanimous verdicts, Edwards was decided during that time, then we weren't supposed to decide it. It was final. And so we should have denied retroactive application. Justice Gorsuch, he simply says, yeah, it's been a long time coming. We should have gotten rid of it right away. He further thought that writs do not permit the court to reopen the judgment when a jurisdiction has declared a decision that's final. Justice Kagan said that the unanimous decision was so clearly a watershed rule that the majority left little choice but to overrule Teague. She said, if there was ever going to be a rule that was an example of the watershed doctrine, it would be the one announced in Ramos. She pointed out also, which I thought was very important, that in the Ramos case, the court vindicated core notions of racial justice. Those laws that allowed non-unanimous verdicts came out of racism and originated in the supremacy of the whites race and the rise of the KKK and resulted in discriminatory effects. And so she said, if an old rule functioned as an engine of discrimination, then the new rule must implicate a watershed rule. So I don't know, I have one more case, Leora, can I? Okay. So my last case that I'm gonna do is an Eighth Amendment case. And this case was about how should we sentence youth offenders. Brett Jones was 15 years old and he was living with his grandparents when he stabbed his grandfather to death. His grandfather had found out his girlfriend had actually moved up with him and was living in his bedroom, and they got into a fight. And he claims that his grandfather was hitting and pushing him, and he stabbed him in self-defense. So the court had to decide whether or not the Eighth Amendment requires a sentence authority to consider whether or not a juvenile is permanently incorrigible before they can impose a sentence of life without the possibility of parole. So whether a minor has to be permanently incorrigible, incapable of rehabilitation before being sentenced to life and parole. I should point out that the Supreme Court began limiting punishment that could be given to juveniles in 2005 when they said that children couldn't get the death penalty. And then in Graham versus Florida, when the Supreme Court said that only children who committed murder could get sentences with life without parole. But if you committed a crime that wasn't murder or a homicide, you couldn't get life without a parole. So then in 2012, the US ruled in Miller versus Alabama that mandatory sentences of life without parole for juvenile homicide offenders was also constitutional because it violated the Eighth Amendment against cruel and unusual punishment. And so essentially what the case was authorizing was a discretionary, it wasn't ruling out that kids couldn't be punished to life without parole. It was simply saying that it had to be a discretionary sentence where the youth of the defender could be considered because the offense that the offender committed reflected an unfortunate and transient immaturity, and that it should be the rare juvenile offender whose crime reflects irreparable corrigibility that receives life without the possibility of parole. And then subsequently in Montgomery, these are the two cases being discussed in the case. The court kind of reiterated its position, and it said that it should apply retroactively. But the issue really becomes, or the discussion that's really being held here is about whether or not it's a substantive rule or procedural rule, and hence what that required. Kavanaugh delivered the opinion, and he said, if you look at the decisions in Miller and Montgomery, they squarely rejected any requirement that a judge or jury imposing a sentence make a separate finding that the defendant can't be rehabilitated. So that's what Brett was arguing. Jones was arguing that the court has to make a finding that he's incorrigible, or the sentencing court has to at least go on the record to explain why he's been giving life without the possibility of parole. Kavanaugh said that all that Miller required was that the age of the offender and attendant characteristics be considered as a mitigating factor when deciding whether to impose a life without parole sentence, to ensure that there was discretion in considering what the possible penalty should be. Justice Thomas delivered a concurring opinion. He agreed with the majority, but he felt that the court should have just simply overruled the Montgomery case. It was his view that Miller announced a procedural rule, which meant that retroactivity would be unavailable to those seeking collateral review, and therefore would have declined to apply Miller retroactively. And he said that, it would have been much simpler to just reject Montgomery, not just in substance, but both in name and substance. Justice Sotomayer authored a dissenting opinion. She says that the majority effectively circumvents stare decisis by reading Miller to require only a discretionary sentence procedure where youth is considered. Children are constitutionally different from adults for purposes of sentencing, and a sentencing judge must actually make the judgment that the juvenile is one of those rare children for whom life without parole is constitutionally permissible. Thank you.